morning, everyone. Welcome if you're joining us. We'll just give everybody a couple of moments to join us, and then we'll get underway. All right, thank you. Hi, everyone, and welcome. My name is Mitchell Zaddo. I'm the Managing Principal at Sharrock Pitman Legal, and thank you very much for joining us today for our next webinar on estate disputes and how to avoid them. Before we get started, we would like to acknowledge the Wurundjeri people of the Koellner Nation as the traditional owners of the land on which our office is located, and we pay our respects to their elders past, present and emerging, and acknowledge their sovereignty was never ceded. And we extend this respect to all First Nations communities throughout Victoria and wherever you may be logging in from. If you haven't joined us for one of our webinars before, or if you have, welcome back. We hope these webinars are a helpful resource to share with you some must-know information and guidance on different topics that may be of interest. You can catch up with the recordings and slides for our previous webinars by heading to our website and clicking the link for our resources page. And there you'll find webinars not just on wills and estates, but also from our lawyers in employment law, business law, property law, and others. But today we're looking at the ways that wills can be disputed and some strategies that can be adopted to help guard against that and to protect the will maker's wishes. Sadly, disputes about wills are increasingly common, and it's something that we're frequently advising on, more than we ever have before, I think. So not only when disputes arise, but also at the time of completing the wills. Prevention is always better than cure, of course, where possible. So we hope today we'll give you some good handles on the things you need to know, either for your own situation or perhaps for your clients if you're an advisor, and give you some food for thought as you're talking things through. So I'll shortly hand over to Binay Prasad, who's our Senior Associate and an Accredited Specialist in Wills and Estates here at Sharrock Pitman Legal, and he will start taking us through today's content. He's got many years of experience in this area, and I know he's looking forward to sharing his knowledge with you today, as are Sarah Slattery and Melinda Van Ruin from our Wills and Estates team. Before I hand over to Binay, a couple of housekeeping items. We are obviously in webinar mode, so your cameras aren't visible in the session, don't worry. And we are recording the session, and it will be available on our website soon. If you have any questions, please feel free to type away in the Q&A box on your screen. We'll try to get through all of the questions sometime as we go if we can. Otherwise, we'll have more time at the end. We are conscious of your time though, so if we do run out of time to answer all of the questions at the end, don't worry, we will get back to you afterwards. And we'll also share our contact details at the end, so you can, of course, feel free to contact us anytime. We are lawyers, of course, so before we begin, we do need to put up some fine print, and needless to say, we can only give you some general guidance in this webinar. Everyone's circumstances are different, of course, and that's really important to keep in mind when you're thinking about your own situation. So please do keep that in mind as we go through the content today. And before doing anything, please do consider getting some specific advice. And again, feel free to contact us if you would like to talk with us afterwards. The final point, really important, this is all, of course, based on the law in Victoria. Estate law is state-based, so although there's some similarities in different parts of Australia, we are focusing today on the law as it stands in Victoria. So without further ado, I'll hand over to Binay. Thank you, Binay.
Thanks, Mitchell. Welcome, everyone. Thank you for attending our webinar today. Just to give an overview of what we'll all be talking about today. I'll be talking about what are called Testators Family Maintenance claims. So they're a very common type of claim where a person's been excluded from a will and they believe that they should have been provided for, so they make a claim against the will on that basis. So, pardon me, just outlining what TFM claims are and also steps that you can take when making your will to prevent a TFM claim against your estate. Melinda will be talking about testamentary capacity, which is another common type of challenge against a will, that the will maker lacked capacity to make their will. So Melinda will be talking about exactly what is testamentary capacity and what steps do we take to prevent a challenge, such a challenge against a will. Sarah will be talking about two topics. Firstly, undue influence. So that's a claim that a person unduly influenced or pressured a will maker to make their will in a particular way, which is also quite common. So Sarah will be talking about what is undue influence and what steps can be taken to prevent such a claim. And Sarah will also be talking about superannuation. So how can you ensure that your superannuation passes to the people that you want it to go to? And also can you prevent any challenges against your superannuation? And then at the end, we'll have a bit of time for any questions that anyone might have. So just moving on to my topic, which is Testators Family Maintenance claims, also known as TFM claims. So these are claims where they're a very common type of claim. They're a claim where basically a person has been left out of a will, and then after the will maker has died, that person makes a claim in court against the estate, claiming that they should receive a greater share. So unfortunately, wills aren't always set in stone. Even if there's a person that you don't want to include in your will, there is a risk that that person could challenge your will after you die. Sorry, next point. Sure. Like I said, they by far are the most common type of challenge, and the most common type of claimant are adult children. So who can make a claim? Well, there's a common misconception out there that anyone can make a claim against your estate. That's not actually correct. The law sets out very strict categories of people that can claim against your estate, called eligible persons. So the most common types of eligible persons are a spouse, de facto partner, child, whether biological or adopted, including either a minor child or an adult child, and also a stepchild. Stepchilds are also entitled to challenge a will. There are some other categories that are less common. A grandchild can also claim against an estate, but they must show that they were financially dependent on the deceased. And also just another member of the deceased household, such as a carer or another family member that was living with the deceased. They're also entitled to make a claim, but again, they need to show that they were financially dependent on the deceased. What kind of matters does the court consider when deciding a challenge against your will? The law sets out a number of factors for the court to take into consideration when deciding whether a person should receive a greater share of the estate. So it's not really up to the judge just to decide what they think is fair or unfair. There are strict factors that need to be considered, such as moral duty. So did the testator have a moral duty to provide for the claimant? So when assessing moral duty, the court usually looks at the relationship between the deceased and the claimant. So generally, it's expected that a deceased has a strong moral duty to provide for a spouse or a partner, also children who are under 18. And generally, the more far removed the relationship is, the lesser the moral duty becomes. Another factor that's also looked at is the size of the estate. So this is a general rule of thumb. It's not the rule of thumb. It's not set in stone, but generally the larger the estate, perhaps the more likely a challenge will be successful, just because the court takes the view that there's more money to go around. The court will also look at the financial need of the claimant. So this is a really important one, and perhaps the most important factor that the court considers. So a claimant really needs to show that they're in financial need of further provision. So if the claimant's quite well off and can't demonstrate that they're in need, it's unlikely that their claim is going to be successful. But on the flip side, if they're quite in a financially poor decision, perhaps on Centrelink or not working or unstable accommodation, then it's more likely that the court will allow them some further provision from the estate. The court will also look at the relationship between the claimant and the deceased. So what we're really looking at here is if the relationship was particularly poor, was of conduct by the claimant, they were aggressive, abusive, violent towards the deceased, or perhaps just estranged from the deceased, then that will reduce the likelihood that their claim will be successful. The court will also look at provision made, if there was any provision made by the deceased prior to the death to the claimant. So But, you know, if the deceased might have left less for a particular claim in their will, but then there's evidence that the deceased actually made a lot of gifts to that claimant prior to them dying, well, then that will probably reduce the strength of the claim. And then on the flip side, the court can also look at contributions made by the claimant. So if and this is particularly relevant in situations such as a family business or family farm, and a particular child might have worked on the farm or in the business for perhaps no wages, or you know, below average wages, or they might have contributed towards renovations towards their parents' property, things like that. If they can demonstrate that they've made contributions to their parents' estate, then it's more likely that the court will decide that they're entitled to some further provision if the provision is inadequate. The court will also look at the position of the other beneficiaries. So if the other beneficiaries are really in financial need as well, then it might make it more difficult for a claimant to prove that they should also get a share and reduce the entitlement of other beneficiaries who really need the money themselves. And finally, the court will also look at any reasons given by the deceased for making less provision for a particular claimant, and we'll talk on about that a bit later. So just moving on to time limits. This is a really important one, but so claims generally have to be made within 6 months of the grant of probate. So when a person passes away, the executor who's named in their will needs to apply to the Supreme Court for a grant of probate before they can get access to the estate. Usually happens about perhaps 6 to 8 weeks or so after death, but can take longer if there's anything complicated. But it's really from that date. So once a grant of probate's made, then a person who wants to challenge the will's got 6 months from that date to lodge a challenge. In some circumstances, the court can allow an extension of time, but the claimant's really going to have to show that they've got a good reason as to why they didn't make the claim within the 6 months. And also, if the estate's already been distributed before they've made their claim, so that the executor's already given the money to the beneficiaries in the will, then the claimant won't be able to proceed out of time because there'll be nothing left to claim. Moving on to the next slide. So I thought, you know, I guess I've kind of outlined the law and how that works in TFM claims, which I know can be a bit dry. So what I want to do now is just move to some more actual examples of situations where a TFM claim's been made and in what circumstances the claimant's been successful or are unsuccessful. So in this situation, which I like to call the no hope or adult son, this is actually a matter that our firm acted in. We acted actually for the daughter, so the other beneficiary. But the circumstances here was mum passed away. She had 2 adult children aged in their 50s when she passed away. Son lived with his mum, had sporadic employment his whole life, had long periods of unemployment, no real assets either. And I guess it could be said that he'd really sponged off his mum for most of his life. On the other hand, the daughter was hardworking. She left home when she was in her 20s to pursue a career in Sydney before moving back to Melbourne and purchasing her own home. At the date of her mum's death, she was a single mother with 2 school-aged children. The daughter cared for her mum when her mum became ill with cancer. However, there was actually evidence that the son was aggressive and abusive to mum. At one point, mum had to take an intervention order against the son to prevent him from having contact with her. But then after that expired, she did allow him to come back home and live in the house again. And there was also evidence that the son financially abused the mum. So mum and the son had a joint account where it was a requirement that for any withdrawals, both mum and the son had to sign. But the son somehow managed to go to the bank and withdraw funds without the mum's consent or signature and without her knowledge. And he actually withdrew $70,000 without mum's knowledge. But to his credit, when mum found out later, he did actually pay it back. So when mum passed away, she left an estate worth about $2 million, which was primarily her family home and some funds in the bank. In her will, she left only $100,000 to her son, and then she left the remainder to her daughter. And the mum's view was really, well, you know, the son's never really made an effort to get a job, and never really made an effort to get a job or stand on those 2 feet. My daughter's been hardworking her whole life, and she's got 2 children to take care of, so I'm going to reward my daughter. That was the mum's thinking in making a will. The son disagreed, obviously, and lodged a claim. So it actually went to a trial in the Supreme Court last year. And like I said, we were acting for the daughter. In the end, the court did note that the son, had been aggressive and abusive to his mum and had engaged in financial abuse, but nevertheless, the court placed greater weight on the son's poor financial position, because he was unemployed at the date of the trial. So the court did award the son $340,000 in the end. Moving on to another case, this is what I call the wealthy stepdaughter. The wealthy daughter, I should say. It's a case of Firth and Reeves, which was a New South Wales case a few years ago. So the deceased had two adult daughters, I'll call them G and R. The estate was worth about $8 million. The will left 2/3 to G and 1/3 to R. So R, who was the client, R wasn't happy with that, so she challenged the will. R and her husband owned a home worth about $850,000. They also had super worth about $700,000. So ultimately, the court refused the claim because it found that, R and her husband already have assets worth about $1.5 million. They're getting approximately another $2.5 million from the estate. And based on that, they're really not in need of any further provision. So I guess what that case shows is that the courts aren't going to look at what's fair. They're not going to decide, okay, there's two daughters, so they should get 50% each. The courts really focus on the financial need of the claim. And if the claimant can't show that they're in financial need, then the court's not going to award them anymore. So on to another case. This is a claim by a stepchild in the case of Mackenzie and Top. So stepchild X claimed against his stepmother's estate. His father had already died, so his father was married to the stepmother. And when the father died, the father left all his assets to the stepmom, so the son didn't get any assets on the death of his father. The stepmother had no children of her own, and the son had grown up in the stepmother's household with his father and lived with her and the father as a family. When the stepmother passed away, the estate was worth around $650,000, but her will left most of the estate to a nephew and the remainder to a few charities. So the the son wasn't included, the stepson wasn't included at all. He challenged the will, and in the end, out of a $650,000 estate, he was awarded $275,000. The last case I wanted to talk about is a blended family situation. This is the matter of Koellner and Spicer, which was a Victorian case from a few years back. The deceased left a de facto partner that had been together for 7 years prior to his death. And he also had a son from a first marriage, an adult son. The estate was quite small. It was only worth about $340,000. The will left everything to the partner, and there was evidence that the deceased was estranged from his son, so they hadn't spoken in a number of years prior to his death. Both the son and the de facto partner were in quite a poor financial position, and ultimately the court decided to award the son an extra $80,000 from that $340,000 estate, which was actually quite a surprising decision. I mean, I guess previously the general perception had been that a deceased had a primary duty to provide for their spouse or partner, particularly when the estate is small. But in this case, even though the estate was small and even though the partner was in financial need herself, the court decided that the son should also get some provision as well. All right, now moving on to what I'm sure is all on your minds. How can I prevent a TFM claim? Well, there are a few strategies that you can put in place. The most effective strategy you can put in place to reduce the risk of a TFM claim is to reduce the size of your estate. So what we're really doing here is, because when you pass away, only assets that are in your sole name will form part of your estate, which can then be challenged. So the less assets that are in your sole name when you pass away, the less assets there is to challenge. And if you can reduce the assets in your name to zero, well, then there'll be nothing to challenge after you've died. It doesn't matter what you've said in your will. There can be consequences from doing this, which I'll talk about in a minute, but just to run down some common strategies to reduce the size of your estate. You can transfer assets out of your name before your death, so you can gift assets to other children or a partner or spouse prior to your death, and so when you pass away, that asset doesn't form part of your estate and can't be challenged. Or you can make your desired beneficiaries, prior to your death, you can make the desired beneficiaries joint owners of your assets. So if you've got a bank account, you can make another person a joint owner of that bank account, or the same with property. And then when you pass away, what the law says is that if you jointly own a property or a bank account, on the death of one owner, the property automatically becomes 100% owned by the surviving owner. It doesn't matter what's in your will, and it won't form part of your estate, so therefore it can't be challenged. If you have a family trust, or you want to set up a family trust, you can also transfer assets to a family trust whilst you're still alive, because assets that are held in a trust don't form part of your estate when you die. The trust will have particular documents which will specify what happens to those assets, and generally it can't be challenged. And finally, another common strategy is to transfer assets into your superannuation, as if, again, superannuation doesn't automatically form part of your estate when you pass away. Sarah's going to talk more about this in her presentation, but with superannuation, you need to make as long as you've made a binding nomination to your desired beneficiary, your super will pass in accordance with that nomination. It won't form part of your estate, and therefore it can't be challenged by a TFM claim. But, and this is a big but, make sure you get financial and legal advice before taking any steps to reduce the size of your estate or to restructure your assets. This is because a restructure of assets could have capital gains tax consequences. So if you're shifting assets between people, or property or shares, that could trigger capital gains tax, which you're going to have to pay. Also, if you're transferring real estate to other persons or making other people joint owners of your real estate, then it's likely there's going to be stamp duty that's payable, which can be quite significant. If you're taking steps to transfer your family home, or making another person a joint owner of your family home, what's called the principal place of residence, PPR. If you have a family home or a PPR, there's usually benefits that are associated with that. Firstly, if it's sold, there's no capital gains tax. Whilst you own it, you don't have to pay land tax. But if you're transferring that to other persons, or allowing other people to become joint owners of your family home who don't actually live there, then you could lose those benefits, those capital gains tax exemptions and land tax exemptions. If you're receiving Centrelink pensions and you're transferring assets out of your name before you die, then that could result in an assessment by Centrelink to reduce your pension. And this really goes without saying. If you're transferring assets to other people or making them joint owners of your assets, then that could involve a loss of control of those assets. And then finally, with superannuation, you have to be really careful, because if there's any financial planners or accountants out there, I'm sure you'd know that there are very strict laws and rules governing superannuation. There's caps as to how much you can transfer into superannuation. So if you breach those caps or those rules or their laws, then there could be tax consequences, or worse still, there could be actual financial penalties involved. All right, if you decided that it's not really practical to restructure your assets or to reduce the size of your estate, then another option you've got is to write what's called a statement of reasons as to why you've left less or no provision for a particular person. The law says that if there's a challenge, the court must take your statement of reasons into account. The statement of reasons won't prevent a claim, so a person can still make a claim, but it will ensure the court has your views and reasons before it, so the court can take that into account and has a balanced view before deciding whether a person should receive further provision from your estate. So what the statement would really outline is, if there's been bad conduct by a particular person and you don't want them to receive anything from your estate, you just really outline in a lot of detail that bad conduct and include any evidence that you might have. And so because obviously once you've passed away, you're not around to give that evidence yourself. So it can be really helpful if you've done a statement of reasons. We usually recommend putting that into a statutory declaration, and then that can be produced to the court in effect as your evidence after you've died. We'd only say get help from a solicitor if you're going to do a statement of reasons. That's because the law sets out certain criteria that really should be addressed in the legislation. So it's best that that criteria is addressed to best protect against a challenge. And also, there have been cases where the will makers made their statement of reasons and the courts reviewed that and really decided that those reasons aren't really relevant or can actually demonstrate that the will maker didn't take proper consideration of a particular person's needs. So that's a statement of reasons can actually work against the estate and help the claimant if they're not properly drafted. All right, so that's my summary of TFM claims. Now I'm going to pass on to Melinda, who's going to talk about testamentary capacity.
Thank you, Binay. So I will be covering the topic of testamentary capacity. This refers to a person's ability to understand and make decisions regarding their will. And this is a crucial aspect of estate planning. Testamentary capacity is governed by the Wills Act 1997, and accordingly, a person must have testamentary capacity in order to create a valid will. The test for testamentary capacity was set out in the case of Banks and Goodfellow. The test set out in this case requires a will maker to understand the nature and effect of making a will, be aware of the extent of the property of which he or she is disposing, and also appreciate the claims to which he or she ought to give effect. So in other words, a person must be able to understand what they're doing when they make a will. They must have a clear understanding of the nature and value of their assets. They must also be able to appreciate the potential claims of people who have a legal right to a share of their estate, such as spouses, children, or other relatives. So how do you determine if someone has testamentary capacity? There is no one-size-fits-all answer to this question, as each case is unique. However, there are some general principles that can help guide us. Firstly, it's important to assess the person's cognitive abilities. This includes their ability to understand and remember information, their ability to reason and make decisions, and their ability to communicate their wishes. Secondly, it is important to assess a person's emotional and psychological state. So a person who is experiencing delusions, hallucinations, or other mental health issues may not have testamentary capacity. Thirdly, it's important to assess the person's awareness of their circumstances. This includes knowledge of their family and social relationships, their financial situation, and their health. If a person is deemed to lack testamentary capacity, any will they create will be invalid. This can create significant legal and emotional issues for their loved ones, as their estate may be distributed according to the laws of intestacy, rather than according to their wishes. So what can you do to ensure that you create a valid will? First, it's important to seek professional advice from a lawyer or other qualified professional. They can help you understand the legal requirements for creating a valid will. They would also be able to assess your own capacity and advise you if there's any additional steps that you can take to prove your testamentary capacity. As the will maker, it is also important to ensure that your wishes are clear and unambiguous. This can include providing detailed instructions for the distribution of your property, as well as naming specific beneficiaries. It is always recommended that you also review your will regularly and update as necessary. This will help ensure that your wishes are up to date and that your will reflects your current issues. At Sharrock Pitman Legal, it is our practice to request a certificate of capacity in certain circumstances when clients are creating a will. This is a legal document that's completed by a medical practitioner, which confirms that a person has the mental capacity to make decisions regarding their will. If a will maker is concerned that their estate may face potential legal challenges, obtaining the certificate of capacity provides valuable evidence that the will maker had the necessary mental capacity when making the will. If a person is creating a will later in life, or if they have a history of mental health issues, obtaining a certificate of capacity can provide peace of mind to both the person creating their will and to their loved ones. It's also important to note that while this certificate of capacity can provide important evidence of a person's testamentary capacity, this is not a guarantee that a will is valid. It is still important to seek legal advice and ensure your will meets all the legal requirements for validity. By following all of these recommended steps, we make it harder for someone to claim that the will maker did not have testamentary capacity. I will now hand over to my colleague Sarah. She will take you through what undue influence is and how superannuation fits into your estate planning.
Thank you, Melinda. Thanks, Sarah.
Thanks very much, Melinda, and good morning, everyone. I'll just speak briefly on undue influence on a will maker and steps to take to prevent both vulnerable family members and yourselves from being improperly influenced in making estate planning decisions and therefore preventing the validity of the will being challenged. Having an up-to-date, properly drafted will can assist in ensuring that there's no undue influence placed upon you when making a will. While a will can, decisions on how you wish to deal with your estate. In the context of drafting a will, undue influence involves a person using their position of trust or their relationship with you or the will maker to influence them to make decisions in their favour at the detriment of other family members or people in the will maker's life. This will generally occur when the will maker is in a vulnerable position, whether elderly or ill, and is dependent on others to assist in other areas of their lives. While a will can be contested if there are allegations of undue influence, the burden of proof will fall on the person alleging that the will maker was improperly influenced when making their will. Testamentary undue influence involves coercion of the testator to draft a will in a way that the testator did not intend. For example, a significant portion of the estate, a valuable item, or even property could be left to the person who's influencing the will maker, of which the gift might be contrary to the actual intentions of the will maker if they were acting freely and without outside influence exerted on them. In order to render a will that has purportedly been drafted under the influence of another, there are a number of factors that must be satisfied to demonstrate undue influence. Firstly, it must be established that the influence is pervasive, coercive, or of moral pressure. In brief, coercion involves pressure of any kind, such as threats, as well as acts that might force a person to yield for the sake of peace and quiet, or to escape the pressures that are applied on them. A person could be subjected to such behaviour by any number of people, and unfortunately, often by family members and even children. Secondly, the effect of this influence must produce provision in the testator's will that is contrary to their true and independent intention. However, it is important to note that the evidence required to establish testamentary undue influence is significant. A person could be, Firstly, the burden of proof for establishing testamentary undue influence lies with the person making the claim. Secondly, the requisite evidence of coercion cannot be presumed. As a result, it is insufficient to establish that an individual had the potential or the opportunity to unduly influence or coerce an elder in regard to their will. In fact, undue influence must be proved directly, and the influence must be related directly to the will itself. While distinguished from more general instances of coercion, the court will certainly assess the evidence as a whole. Fortunately, this high evidentiary burden is frequently problematic for challengers. As a result, there's been very limited circumstances where undue influence is solely relied upon by a claimant when making an allegation that undue influence existed at the time of making the will. Other issues would also be raised, including a lack of testamentary capacity, which Melinda touched on today, which often goes hand in hand with undue influence. As such, it's again important to ensure that all estate planning instruments are drafted and executed while a testator has full capacity. By having your will drafted by an independent professional, safeguards against potential beneficiaries influencing your decision-making process can be put in place to ensure that your thoughts, intentions, and wishes in respect to the distribution of your assets are properly considered and carried out. While it's not always possible, we would always recommend having your estate plan in place before you become more dependent on family members or friends for care and assistance in your life.
I think it'd be fair to say too, would you say, Sarah, sometimes if we're acting for adult children who are concerned, sometimes there's a choice of whether to go down the undue influence path or just accept the will, but then make a testator's family maintenance claim along the lines of what Binay was talking about earlier. Some of that strategy needs to come into it.
Certainly.
Right.
So that's just an overall brief rundown of what testamentary capacity is, and undue influence and measures to put in place to protect against any claim resulting from those factors. So following on from that, I'll just touch briefly also on another important aspect that needs to be considered when making an overall estate plan. So more and more superannuation is becoming a significant resource and asset of an average Australian. What is not commonly known, and what Binay touched on also, is that when you die, your superannuation death benefits and any insurance that's connected to your superannuation does not automatically form part of your estate, unlike other solely owned assets that you have, and are therefore not automatically covered by your will. This is because superannuation is not actually owned by you personally, but is instead held by the trustee of the superannuation fund on trust for you. This is the case whether you have an industry super fund or a self-managed super fund. So after your death, the trustee of a superannuation fund will pay your death benefits in accordance with any valid nomination that you make, or otherwise if no nomination is in place, in accordance with the rules of the superannuation fund and superannuation laws. It's therefore critical to make sure that you have a valid nomination in place at the time of your death. So who can you nominate to receive death benefits? There's only a certain category of people who are eligible to receive your death benefits from your super fund. Initially, a surviving spouse or de facto partner, a dependent person, including minor children, an interdependent person. You can nominate your estate as your beneficiary, or a combination of any of the above. So if you make a nomination to pay your death benefits to someone who falls outside of any of those categories, for example, if you want in a sibling, niece, nephew, parent to benefit from your estate, then the nomination will be rendered invalid just because it's not one of the eligible claimants, and will allow the trustee to exercise their discretion on how that benefit will be paid. So just in a sense of what kind of nominations you can make, there are two types of nomination to put in place: a binding or a non-binding nomination. We often advise clients to make binding nominations. This is because it binds the trustee of the super fund to pay your death benefits in accordance with that nomination. The trustee of the fund must follow the nomination, except, as I said, in circumstances that the nominated person is not part of those eligible category of beneficiaries. So in contrast, a non-binding nomination will be considered by the trustee of the fund, but it's not binding on them to make a distribution in accordance with that nomination. So ultimately, they'll retain the power to decide how those benefits ought to be paid. Also, so outside of the binding and non-binding, there are also lapsing and non-lapsing nominations. Most commonly with industry funds, you're only allowed to make a lapsing nomination, which means that it's valid for 3 years, depending on the fund, from the date of signing, after which the nomination will lapse. It's therefore critical to ensure that these nominations are kept up to date and that in accordance with what the fund requires. In some circumstances, especially in regards to self-managed funds, you can make a non-lapsing nomination. And again, this will depend on the rules of the fund or the trustee. So if you die without a valid nomination in place, then the trustee of your super fund has the power to decide on your death how the benefits ought to be paid. In making this decision, they'll take into account superannuation laws and the rules of the fund. They may also consider terms of your will, but are not required to do so. The fund may distribute the death benefits in accordance with the same categories of person to whom you may have nominated and including your estate. So just in terms of what can happen if someone's not agreeing with how a death benefit has been paid out in circumstances that there's not binding or valid nomination in place, super fund trustees must act in good faith and make reasonable and responsible decisions. But there have been many cases where decisions in respect to estate distributions are disputed. So some of the situations where disputes have arisen include where the deceased was married but not yet divorced and had a de facto partner at the time of their passing, when there are competing claims between children as to how the death benefit is apportioned between them, when a beneficiary requires greater provision due to financial concerns or health issues, when there are blended families in circumstances where the actual form or content of the nomination in place was questionable, and touching on what's already been discussed today, where the decision-making process undertaken by the super fund is questioned by affected people, and in circumstances where there was little or inadequate estate planning undertaken by the deceased. So if there is a question placed on how the super fund has paid a benefit, if it's to a wrong person or the proportionality is in question, then you're entitled to seek an internal review with the relevant fund within 28 days of being notified of the original decision. And on review of that decision, if you're dissatisfied with the response by the trustee, you're entitled to apply to the Australian Financial Complaints Authority, again within 28 days of that response of the review. So the Complaints Authority is an independent body that works with parties through the dispute resolution processes in matters regarding financial services and products. So the best way to avoid leaving your loved ones, family members with a superannuation dispute is to ensure that you have an effective and valid nomination in place at the time of your death.
We've had a comment, Sarah, and thank you, person who sent the comment in, just to clarify that a child is a potential beneficiary of superannuation as well. We sort of factored in as an interdependent person, but yes, children certainly can receive superannuation. There may be a question mark over whether they are eligible for concessional tax treatment, depending if they're a minor or an adult, and there's rules about that, but certainly superannuation can be paid directly to a child if that's what the nomination sets out.
Yeah, I'd also add to that, Mitchell. Sarah was correct in saying that a deceased estate can also be nominated as a beneficiary of super, so that's particularly useful if you want to nominate another person, such as a sister or grandchildren, as the ultimate recipient of your super, then you can nominate that it gets paid to your estate, and then in your will, then you'd actually nominate the ultimate beneficiary, because the super will get paid in accordance with the will. But if you think there's going to be a challenge against your estate, then we would usually recommend that you don't nominate the estate, because that would just divert the super to the estate, which can then be challenged by the claimant.
Sometimes there's no perfect solution, everyone, but it's a matter of looking at all of the options and the issues at play. Thanks, Binay. Thank you, Sarah. We've got time for questions. If anyone would like to ask any questions. In the meantime, I'll just let you know and direct you to our website, where you can find a lot more information about this sort of stuff. We're constantly providing some information through our site, which we share through our social media channels, Facebook, Twitter, LinkedIn in particular. So things that we're constantly and regularly seeing come up as issues in our practice, but also developments in the law, because as we know, the law is never standing still for very long. So if there is something happening and you're wondering and you want some information, feel free to check out our resources part of the website, and there might be some information there, or you can also, of course, give us a call or an email. And we've also got some downloadable publications through our website as well, some legal guides to estate planning, particularly after separation. Sometimes that's a very difficult time, of course, and things can be overlooked. Sarah touched on issues where nominations for superannuation are in place, for example. There's a separation and the person forgets to go and update their superannuation where they nominate their former spouse, who they may still be legally married to. Powers of attorney, wills should all be looked at in the event of separation, of course, and some information generally about probate and estates and what that involves and requires. So hopefully those resources are of interest to everybody. And before we wrap up, we haven't had any questions, so if you would like to take our details down at the end, feel free if you're more comfortable doing that. A quick plug, if you will allow me, if you're interested in looking at enterprise success, if you're running a business or other organisation, can I commend to you David Sharrock's book, Fighting for Enterprise Success Through the Eye of the Tiger, which is available in hard copy and an ebook. Contains lots of guidance and wisdom and reflections from David, as well as nearly 70 self-assessment tools, samples, templates to help you along, including some that have worked for us in our practice, which you might be able to find of benefit and adapt in yours. So it may seem biased, but it really is an excellent tool, and recommend you have a look at that if that's of interest to you. So now it's time to wrap up. Thank you very much again for joining us, everybody. As I've said before, if you do have any queries on anything that we've raised today or on anything else, of course, please do feel free to get in touch anytime, and also have a look at our social media channels and follow those to keep up to date with things. In the meantime, we wish you all the best and hope to see you next time. Thank you. Have a nice day.